Friends, today is 223rd Friday group meeting. Special lecture, you can say special session. The speaker is our beloved senior advocate. Last one, part 1, part 2, part 3. He addressed our Friday group. Today is a part 4th. New criminal laws, otherwise also called as BNS and BSA. Bharatiya Nyaya, Sanhita BNS part this one. And second is Bharatiya Sakshya Adhiniyam BSA, Bharatiya Nagarik, Suraksha. These are the Hindi names. So, sir, please initiate this thing.
Honorable Justice Kattugunagam, Honorable my esteemed friend Mr. Rao, Senior Advocate Mr. Balaji, and all other our friends. During the past 3 sessions, we were able to cover only one act, that is BNSS, which has repealed the CRPC. Today, I propose to deal with the Bharatiya Sakshya Adhiniyam, in short BSA, which has repealed the Indian Evidence Act of 1872. Before going into the changes made in respect to the provisions of the old Evidence Act, let us first look into section 170 of this BSA, which has repealed the Evidence Act and saved some of the actions already taken. Section 170 reads like this: the Indian Evidence Act of 1872 is hereby repealed. 2. This is very, very important. Notwithstanding such a repeal, if immediately before the date on which this Adhiniyam comes into force, there is any application, trial, inquiry, investigation, proceeding, or appeal pending, then such application, trial, inquiry, investigation, proceeding or appeal shall be dealt with under the provisions of Indian Evidence Act of 1872 as in force immediately before such commencement, as if this Adhiniyam had not come into force. The saving clause is very, very important. What does it convey is that so far as the matters which were already pending, like trial, inquiry, investigation, then appeal shall be dealt with as per the provisions of the repealed Indian Evidence Act, as though this Adhiniyam had not come into force. Now, when we dealt with BNSS, we referred to section 531, which repealed the Code of Criminal Procedure 1973 and also saved some of the provisions. You may kindly have, because we have already dealt with the same, I do not want to be so elaborate on that. 531(1) subsection B of the BNSS states like this: all notifications published, proclamations issued, powers conferred, forms provided by the rules, local jurisdictions defined, sentences passed, and orders, rules, and appointments, not being appointments of special magistrates, made by under the said code, which are in force immediately before the commencement of this Sanhita, shall be deemed respectively to have been published, issued, conferred, specified, defined, passed, or made under the corresponding provisions of this Sanhita. This kind of provision is not found in the section 170 of this BSA. So therefore, if any order is made, suppose let us say that the trial is going on already, the trial of the case will continue as per the provisions of BNSS that we have already seen. As per the subsection B of section 531, if the trial concludes today and a judgment is given as per CRPC. But by fiction, the section says that it shall be deemed to have been made under the BNSS, under the corresponding provision in the new code. Therefore, I told that any appeal or revision against such an order made today, following the old procedure, used to be made under the new code. This we already clarified. Now let us come to this Adhiniyam. Trial commenced before 1/7/2024, that is before a crucial date, trial had commenced. 50% of the evidence was already recorded. The rest of the evidences are to be now recorded. Now as per this provision under the Evidence Act only, Old Evidence Act. Now applying the principles of Old Evidence Act, there are certain changes made in the new code, new act. Now applying the principles relating to the Old Evidence Act, judgment is to be delivered today. After the judgment is delivered, as we have seen under 531 of the BNSS, appeal is to be made under the BNSS, not under the CRPC. While dealing with the appeal, which is fresh, it is not old appeal. It is a fresh appeal. Whether the Old Evidence Act is to be applied or this Adhiniyam used to be applied, this BSA used to be applied is the question. If you read this section 170 plainly, you may have an initial impression that because the appeal was not pending as on the date of coming into force of the Act, we have to follow only this BSA while dealing with the appeal. This may be the initial impression. That impression may not be correct in view of the fact that the Evidence Act is a procedure which regulates the court as to how to appreciate the evidence. Till yesterday, in the same case, appreciation cannot be like A procedure, and today suddenly when appeal is heard, it cannot be changed into B procedure. It should be the same. Standard of appreciation must be the same. Applying the Evidence Act, the trial court has appreciated the evidence by following certain norms and following certain standards. The very same norms and very same standards are to be applied when you are hearing the appeal also. Because the appeal is filed today, you cannot apply a different norm or different procedure or different parameters and take a different view. This will be illogical. Therefore, I would say that by referring to this section 170, a clear understanding will make us to say that though appeal is filed today, though revision is filed today, though any other proceeding is initiated today, in respect of a case which was decided as per the Evidence Act, used to be continued as per the Evidence Act only, not under this Act. For example, I will tell you, under the old Evidence Act, if you look at section 114 of the 14, there is a presumption. Presumption is that an accomplice is unworthy of credit. Right? An accomplice is unworthy of credit unless his evidence is corroborated in material particulars from independent sources. You please kindly see, I will read the illustration. Illustration B of section 114 of the Evidence Act. An accomplice is unworthy of credit unless he is corroborated in material particulars. Okay. Therefore, if there is no corroboration, then the presumption is that he is unworthy, which states that you cannot convict an accused based only on the uncorroborated testimony of an approver. This is the understanding of this illustration. Now, if you look at section 133 of the very same Evidence Act, now, it reads like this. An accomplice shall be a competent witness against an accused person, and this is important. A conviction is not illegal merely because it proceeds upon the uncorroborated testimony of an accomplice. So, illustration B to section 114 says that an accomplice is unworthy of credit unless his evidence receives corroboration. The presumption will remain, therefore you cannot convict. But this section 133 is clarificatory in nature, which says that it is not illegal, even though there is no corroboration. You can convict still. There appears to be some conflict. But as a matter of fact, these two provisions were reconciled by the Privy Council Bhuban Isagu, and then also in Harcharan Gurmi by a constitution bench. Harcharan Gurmi, it is 1950. Yes. The judgment is very interesting judgment. Nyaya 1964 Supreme Court 1184. Harcharan Gurmi versus State of Bihar. It is a constitution bench judgment. Please kindly read the judgment. So as per this judgment, a balance was struck between these two provisions and said that it is only rule of prudence. It is only rule of prudence, it is not rule of law. It is only rule of prudence that the court has to always expect some corroboration. Therefore, under the old code, under the old Evidence Act, suppose the presumption is not raised by the court. 114 gives discretion to the court, either to raise a presumption or not. Court doesn't raise a presumption. Or because it is a rebuttable presumption, the presumption so raised is rebutted. Then as per section 133, it is not illegal to convict based on uncorroborated testimony of an accomplice. This was the original position. In these two judgments, it has been very clearly held by the Privy Council as well as by the Honorable Court. In between came that what is that? So that is 1954, 57 Supreme Court. So these judgments very clearly said that it is the balance was struck. And as a rule of prudence, you have to look for corroboration. Now, 114 has not been changed in any manner, and verbatim it has been retained in the new Evidence Act. But what they have done is in section 133. 133, which is clarificatory in nature, has been now amended. You please kindly have a look at section 133 of the old Act, and now under section 138. See, I will read the provision. An accomplice shall be a competent witness, same thing as we found in the old Evidence Act. And a conviction is not illegal, same language, if it proceeds upon the corroborated testimony of an accomplice. What was there earlier? Uncorroborated testimony. It was clarificatory to say that it is not illegal to convict on the basis of an uncorroborated testimony of an accomplice. That was the original law. Now they say, no, it is not illegal to convict on the basis of an uncorroborated, upon the corroborated testimony of an accomplice. So this gives an impression now that you cannot convict an accused based solely on the uncorroborated testimony. You can convict an accused. Now what was the rule of prudence has been now indicated as a rule of law now. That's a distinction made between these two. Earlier in Harcharan Gurmi and also in Kashmira Singh, the Supreme Court said that it is only rule of prudence. Expecting corroboration from some other source to the evidence of an accomplice is only a rule of prudence. That was what said. Now it has become a rule of law. Now the amendment says that you can convict an accused on the basis of corroborated testimony, not uncorroborated. This is the major change made so far as an accomplice is concerned. This has got some relevance to section 170. Suppose the appeal was pending, trial was going on. Approver, the accomplice had already been examined. There is no corroboration. Trial court convicted the accused based on the uncorroborated testimony of an accomplice. The court used its prudence and said that though there is no corroboration, it is not illegal to convict him based on the evidence of an approver. Therefore, the trial court has convicted him based on the uncorroborated testimony of an approver. Right? Now, appeal is filed today. While hearing the appeal, if you are going to apply the new BSA, then the judgment, the conviction is to be set aside simply, because it is uncorroborated. New Act says no, don't convict unless it is corroborated. There is no corroboration. Therefore, the judgment of the trial court giving conviction is to be now set aside simply on the basis on applying this provision that there is no corroboration, therefore I am acquitting. This kind of interpretation is nothing but an absurdity. The trial court applied one standard, the trial court applied one procedure, the trial court applied one parameter. Now you are applying in the same case, you are applying different parameter, different procedure and different yardstick. This cannot be the intention of the law. Therefore, I would say that so far as section 170 is concerned, in respect of those cases which are pending trial already, then until the logical end is reached before the Supreme Court, the same old Evidence Act is to be applied. This is in respect of trial. Now, section 170 also say that investigation, if pending already, used to be conducted as per the old Evidence Act only. Right? As per the old Evidence Act, it is to be conducted. Alright. Investigation is conducted as per the Evidence Act, and today charge sheet is released. Now the court takes cognizance today. Now, while trying this case, which is a fresh case so far as the court is concerned, whether the court is going to apply the old Evidence Act or the court is going to apply the BSA. So far as this is concerned, my understanding would be that the court has to apply the standards of this BSA only. So investigation may be, that is, investigation is nothing but a collection of evidence. They have to collect a lot of evidence as per the old Evidence Act. Now when the trial commences today, this is to be done by applying the standards of this Adhiniyam only, that BSA only. This is my understanding, but anyhow, this matter needs to be settled by the Honorable Supreme Court. Each High Court may take a different view. Each trial court may take a different view. Because my understanding is one thing, your understanding may be different. But we have to initiate a debate on this. Until it is settled by the Honorable Supreme Court, there will be some confusion. So, in applying this section 170, this is in respect of retrospectivity of the provisions of BSc. With this, I think that I can stop my discussion on section 170. Now let us go into the act as to what are the major changes made and how it is going to affect, or how, in other words, it is going to confuse. We will see that. Now let us come from the definition clause. Now come to section 2. So far as the section 2 deals with the definition almost all the definitions of the key words like proved, not proved, disproved, and similarly presumption, then conclusive proof, all those definitions have not been in any manner disturbed or modified. Same definitions are retained, but what they have done is they have changed the order. Now they have done it in alphabetical order. Earlier, if you look at section 4, 3 definitions you will find. It's a very good scheme. Presumption, may presume, shall presume, conclusive proof. All were there in one section, section 4. Now, what they have done away with section 4, they have taken these 3 definitions and put it in section 2 in alphabetical order. So what comes first is conclusive proof, because it is C. Then comes the other 2. May presume comes, then shall presume comes at the end. So in different places it is located. That's all is the change made so far as the definitions are concerned. Very importantly, they have, though the definition of the word document has not undergone any major change, they have added only illustrations. Now, what is the document? Now, we have already in my earlier, one of my lectures, we have very elaborately dealt with as to what are the documentary evidences which are made available in the criminal cases. Now, what is a document? Document is defined in section 2(1)(d). Document means any matter expressed, described, or otherwise recorded upon any substance by means of letters, figures, or marks, or any other means, or by more than one of those means intended to be used, or which may be used for the purpose of recording the matter. All old code, old Evidence Act, no change. And includes electronic and digital records. If you look at the old Evidence Act, the definition would not include digital records. The definition of document is this: all documents including electronic records produced for the inspection of the court. Such documents are called documentary evidence. So therefore, earlier what was included by means of amendment was electronic records. So document includes electronic record also. This is important. Other things are old, so I do not want to repeat. What was done by amending the original Evidence Act was to include electronic records into the definition of documentary evidence. Now, in section 2, what they have done is, apart from electronic evidence, they have also included digital records. So now there are 2 kinds of documents. Leave alone the old ones. In this modern days, in this technological era, there are 2 things which have been added. One, as per the Evidence Act, electronic records, which include electronic record. That was the original Evidence Act. Now they say and digital records. So both electronic records and digital records are 2 different kinds. They are not one and the same now. Now, having said electronic, what are the electronic records? The term electronic record has not been defined in the original Evidence Act. We have to go to the Information Technology Act. Information Technology Act defines an electronic record. I quote, electronic record means data, record, or data generated, image, or sound stored, received, or set in an electronic form, or microfilm, or computer generated microfiche. So therefore, what is an electronic record has been defined in the Information Technology Act, though not defined in the Evidence Act. We borrowed the same definition from the Information Technology Act. But now they have in this BSA included digital records. What is a digital record? Nowhere I could find. Neither defined in the BSA nor is it defined in the Information Technology Act. So we have to fall back on the common parlance understanding of what is a digital record. But after having read various substances on this, what I understand is that electronic record is the one which can never be manipulated, changed, modified, etc. as per the definition. Electronic record is the one which can never be changed. It is original. For example, one of my juniors gave this example. You receive an air ticket.
I am for respondent 2 in item 45.
That air ticket is an electronic record.
In this matter,
Air ticket is an electronic record because you cannot manipulate, you cannot change. It is permanent in nature. This is an electronic record. Then what is digital record? You can send a message by WhatsApp or through email, which can be modified, which can be changed. This is digital record. So electronic record, in my understanding, you may have different opinion. I leave it to you. In my understanding, electronic record means a record electronically created, stored, etc., which can never be changed by anyone. This is a permanent one, unless the author himself changes. Whereas there are certain electronic records, electronically made documents which can be modified, changed, etc., like email, etc. These are all digital records. These are different. Under the old Evidence Act, only electronic record was defined as a document, defined as a documentary evidence. Digital record was not at all included separately. But in the course of understanding that provision, we were just mixing both. Without understanding the difference between these two, we are using the same standard for both digital record and electronic record. Now they have clarified that. But having done, they have not defined as to what is a digital record. Now let us go to the illustration class. So please keep in mind before going to the illustration, one thing very clear, that document includes an electronic record and a digital record. Both are documents, which means they are primary evidence. Now let us go to the illustration. Illustration 2.1 of the section, Roman letter 5, illustrates like this. An electronic record or emails, server logs, documents on computer, laptop or smartphone messages, websites, locational evidence and voicemail messages stored on digital device or documents. So an electronic record which is stored in a digital device is also a document that is defined, right? Therefore, the storage point may be a digital device, but what is stored is an electronic record. Still, it is a document that is defined here in the, that is the illustration. Now, very importantly, section 2.1e of the BSA, which is corresponding to the definition of the term evidence under the old Evidence Act. Evidence means either oral or documentary as per the Evidence Act. What is oral? That is defined in the old Evidence Act like this. Evidence means and includes all statements which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry. Such statements are called oral evidence. Any statement made by a witness in court is oral evidence. Simply put it, any statement made by a witness in court during trial or inquiry is oral evidence. Now, what they have done in this BSA, evidence means and includes all statements, including statement given electronically, which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry, and such statements are called oral evidence. So earlier oral evidence means the witness must state in court, that will be reduced to writing. This is called oral evidence. Whatever is spoken in court alone was considered as oral evidence. Now, whatever is spoken even through electronically is also oral evidence. So, suppose a witness is examined through the video conference. It is recorded here in the court. Though the communication is made through electronic mode, though the witness is not present in court, if it is recorded in a computer here, in a storage point here, though it is an electronic record, it is only oral evidence. So this can be understood in a different way also. Under the old Evidence Act, if witness comes to the court and deposes, it is typed out. He signs that. Now it is now in a document which can be read. Is it documentary evidence? No. What the witness said in court is oral evidence. It is written in a paper. So the paper is not evidence. What he spoke in court is evidence. Therefore it is oral evidence. Apply the same understanding here. The witness, instead of coming to the court, sits elsewhere, speaks through the electronic mode. It is either typed in court or it is as such recorded in the computer. Though it is recorded, so it is still considered only as oral evidence. So the distinction between oral evidence and documentary evidence is very, very important when you go to the admissibility of these two. When you go to section 59 and 60 and 63 to 72 of the old act and the corresponding new provisions, you will understand why I am so much focusing on the difference between oral evidence and documentary evidence. Now, having said this, let me move on to the definition of document. Under the old code, see, documentary evidence, all documents including electronic record produced for inspection of the court, such documents are called documentary evidence. So all documents like a sale deed, agreement for sale, will, gift, anything including electronic record. Please note one thing, what is missing in the old Evidence Act? Digital record is missing. Under the Evidence Act, only electronic record is a documentary evidence as per the old act. Now in the new act BSA, what they have done is this: all documents including electronic or digital records. So digital record is now introduced into the definition of a document, and therefore today the definition of document includes not only electronic records but also digital records. Both are documents, right? Please keep this in mind. There are two things. This is a major change made. They have included digital records also into the definition of a documentary evidence. This is a major change. This is going to have some bearing when we are going to deal with the other relevant provisions on this. Now, I think that we can straight away go to those provisions. Please come to old section 59 and 60 of the Evidence Act. Immediately we will go there. '59 corresponding new provision is 54. No change. All facts except the contents of document may be proved by oral evidence. So I have told you what is oral evidence. Electronically, if a witness speaks, it is oral. It is not documentary evidence. Therefore, it is admissible under section 59 of the old code, now section 54 of the new act. Now, section 60 is important. Oral evidence in all cases, whatever be direct, if it refers to, see, if with the thing to be spoken, the person to be seen, the person who is seen has to give evidence, this we have already dealt with. So far as section 60, so what are all the oral evidences which are direct, has also been dealt with simply by reproducing the same provision. Now, let us go to section 61 of the old act and section 56 correspondingly to the new act. In respect of proof of documents, we have already seen two new things. One is electronic record is a document. Two is digital record is also a document. How to prove those two things? Now, for that we have to come to section 56 of the new act and old act, section 61, which says, I am reading section 61 of the Evidence Act. Proof of contents of documents. The contents of document may be proved either by primary or by secondary evidence. Primary evidence means, as per section 62, primary evidence means the document itself produced for the inspection of the court. So if you are able to show that this is a digital record, because it is a document as defined, mere production would be enough to prove the contents. Right? Suppose you produce a sale deed into court. You produce a sale deed. Mere production is enough to prove the same because the court will inspect the document. That is, primary evidence is the document itself. That's what I am trying to impress upon. So an electronic record or a digital record is a document and therefore it is primary in nature. Mere production is enough. So later I am going to contradict myself. So this is what is said in section 62. Now section 57, the corresponding new provision, primary evidence means the document itself produced for the inspection of the court. Same thing. It says that if you produce the document, it is primary evidence. The primary evidence must be produced, which includes those two things also. Now they have added some explanation to this section, which was not there earlier in section 62. Now they have added some explanations. What are those explanations? Number one, explanation number 4, where an electronic or digital record is created or stored and such storage occurs simultaneously or sequentially in multiple files, each such file is primary evidence. No dispute over this. There can be any number of documents. Same message, I am sending one message to several people. You get it in your document, in your device, you get it in your device, you get it in your device. All are primary evidences. You can produce your instrument, you can produce your instrument, you can produce your device. All are primary evidences, simultaneously or sequentially created. In regarding this explanation, we have got no quarrel over. The next one, explanation 5, has got some problem in understanding. I will read it, please kindly, closely follow it. Where an electronic or digital record is produced from proper custody, such electronic and digital record is primary evidence unless it is disputed. What is this? Earlier we have seen in the definition class, what is a document? Electronic evidence is a document. Electronic record is a document. Digital record is also a document. Document means it is primary. Now, this explanation is contrary to the substantive provision. This says, where an electronic or digital record is produced from proper custody, such electronic or digital record is primary evidence. So, this is highly contradictory to the substantive provision, which declares that every electronic record or every digital record is a document and therefore it is primary. Now it says, unless you produce it from proper custody, it is not primary evidence. The only explanation, you know, what is the scope of an explanation to a substantive provision? If any explanation runs contrary to the substantive provision, the explanation is to be struck down. It is to be struck down as it is violative of the substantive provision. So this explanation, I don't think that this is correct. Then the next explanation, number 6 is, where a video recording is simultaneously stored in electronic form and transmitted or broadcast or transferred to another, each of such stored recording is primary evidence, no dispute over that. Where an electronic or digital record is stored in multiple storage spaces in a computer resource, each such automated storage, including temporary file, is primary evidence. So, as per what the provision which we have already dealt with, two things are very clear. One, electronic record, digital record are documents and therefore they are primary evidences. If they are simply produced for the inspection of the court, the contents are proved as per section 62 of the old act and referable to section 57 of the new act. Primary evidence means the document itself. Primary evidence means document itself. Therefore, this explanation is contrary to the substantive provision, therefore it is to be struck down. That is one thing. Now, what is the effect of this? Let us go to the next provision, secondary evidence. Now, secondary evidence, I am reading section 63. There is a problem in this provision also, that is in the corresponding provision. Secondary evidence includes certified copies given under the provisions hereinafter contained, etc., all old thing under the old act. Copy taken, copy compared, printout, all these things are all secondary evidence. Now, in 58 of the new act, if you please kindly see, there is some change made. Oral admissions are secondary evidence. You just see here, secondary evidence includes oral admissions. Secondary evidence includes written submissions, written admissions. These two, that is admission. Suppose in a proceeding, a party admits a fact. He says, the section says it is secondary. Secondary means there must be a primary one. So what is primary then? Secondary evidence can be let in if the primary evidence is not available to be produced in court. Then only you can produce the secondary evidence. For that you have to lay a foundation. That primary evidence was lost, it was destroyed, it is in the hands of the other man, therefore I am not able to produce the primary evidence. So when the primary evidence is not available, then only you can produce, you are permitted to lead secondary evidence, that is to produce a copy, a certified copy, true copy, etc., etc. Now, they say as per this section, oral admission is also secondary evidence. What was there originally? Certified copies given under the provisions hereinafter contained. Certified copy. When original is not available, you can put a certified copy. Original is a primary evidence, this is secondary evidence. right? Next one, copy is made from original by mechanical Xerox copy. What is original? Original document. Xerox copy is secondary. You can lead secondary, you can get the secondary evidence admitted in evidence, provided you say that the original is lost, destroyed, etc., etc. So for every secondary evidence, there is a primary evidence. Now, oral accounts of the contents of a document given by some person who himself has seen it. So I am giving oral evidence about the contents of a document which I had seen. That document is primary, my oral evidence is secondary. There cannot be a secondary evidence without there being a primary evidence. It is very common sense understanding. Now, if this is applied, how do we understand this? Definition. Oral admission is secondary evidence. Suppose during the course of evidence a person admits something orally. They say it is only secondary evidence. Then what is primary then? Something must be there as primary. There is no primary. Without there being a primary evidence, how can there be a secondary evidence? I can lead a secondary evidence provided primary evidence is not available. When there is no primary evidence at all in existence, never it has come into being. How can there be a secondary evidence? So this provision is also, in my considered view, is highly arbitrary, and this also needs to be checked down by some court. Then written submissions. So written admission. Suppose I give it in writing that I am admitting some document or something like that. I admit. I give in writing to the court. No, this is only secondary evidence. Then what is primary for that? There is no primary evidence. Therefore, this is also wrong. Then one more thing. This oral admission is referred to in section 23 of the admission of the Evidence Act. Oral admission is nothing but substantive evidence. Oral admission by itself is enough to decide a case. Just see, oral admissions as to the contents of a document are not relevant unless and until the party proposing to prove them shows that he is entitled to give secondary evidence of the contents of such a document under the rules hereinafter contained, or unless the genuineness of the document produces is in question. So which means admission is the best evidence. We normally say admission is the best evidence. Admission is relevant. Mere admitted fact need not be proved. Correct? That is section 58 says admitted fact need not be proved. Suppose I admit a fact, it requires no proof at all. Now they say in this provision, admission either oral or written is only secondary evidence. If it is secondary evidence, it can be rejected because you are not laid foundation as to why the primary evidence is not produced. Then we have to trace out as to what is the primary evidence. There can be no primary evidence at all. Therefore, this is quite contrary to the provision which have been interpreted under the Evidence Act for about 150 years. It is totally wrong. Then let us come to the next definition. Yes. Section 65. When secondary evidence can be let in? Secondary evidence may be given of the existence, condition or contents of a document in the following cases, namely when the original is in the possession of the other party, then it is destroyed, etc., etc. 65, I do not want to go into that. 65 is simply reproduced in section 60 of the new act. So if you want to lead secondary evidence, you have to prove that the primary evidence is lost, it's not available. So that is again wrong. One more thing, one more inclusion is section 58, Roman letter 8. Evidence of a person who has examined a document, the original of which consists of numerous accounts or other documents which cannot conveniently be examined in court, and who is skilled in the examination of such documents, is also secondary evidence. What does it mean? Suppose a person who is skilled in a particular field, he reads a document, he compares it, he comes to court and gives evidence on that. They say it is only secondary evidence. It is only secondary, not primary. This is contrary to the old section 45 of the Evidence Act and the new section 39, opinions of an experts. See, under the old act, who are the experts? Under section 45, when the court has to form an opinion upon a point of foreign law, a man who knows the foreign law is an expert in that field, or of science or art. As to the identity of handwriting or finger impressions, the opinions upon that point are person specially skilled, underline this word, person specially skilled in such foreign law, science or art or any other field, or in questions as to the identity of handwriting or finger impressions or relevant facts, such persons are called experts. So an expert who has got a special skill in any one of these categories. Now let us look into the new provision, section 39, where they have added one more thing. That is, apart from science or art, any other field. What is that field? I have been thinking of finding out some field where there is an expert. What is the field? One illustration. To my little knowledge, yes please. To my little knowledge, I am not able to find any example for that. So let us assume. Let us come to this provision now, which says, this illustration I was reading. Yes. Evidence of a person who has examined a document, the original of which consists of numerous accounts or other documents which cannot conveniently be examined in court, and who is skilled in examination of such documents, which means he has got a special skill in a field. He is an expert. His evidence is therefore relevant as per section 45 of the old act and the corresponding new provision. Now, as per section 60 of the old act, oral evidence must be direct. The sixth one is the opinion or to the grounds on which that opinion is held, it must be evidence of the person who holds the opinion on those grounds. So, the opinion of an expert is also oral evidence. Not only oral, it is direct evidence. His evidence is straight away, substantive, it can be acted upon. But now, this provision says, no, it is not primary, it is only secondary. The concept of primary or secondary is known only to documentary evidence. In oral evidence, there is no primary or secondary, there is no such classification. But now, oral evidence of an expert, which according to section 60 of the old act and corresponding new provision, is direct evidence, therefore it is admissible, it is not secondary. This is quite contrary to that. There are now two conflicting sections. One section saying that evidence of an expert is primary, is direct oral evidence. Another section saying no, it is only secondary. Secondary means there must be something which is primary. Primary means some document. There are two conflicting provisions now. This, in my understanding, is going to create further confusion only. Nothing else. Now, this is one thing. Now let us come to the electronic evidence. Now, you know very well that after this section 65A and 65B, were introduced. We have seen many judgments of the Supreme Court and various high courts. Until today, law is so volatile and it is not certain. The last judgment we have from the Honorable Supreme Court is that Arjun Pandit Rao's case, where the Honorable High Court, the Supreme Court has held that when Section 65B certificate is required and when it is to be produced and who is competent to give the certificate, etc. I do not want to go into that right now. Now, in this background of the law laid down by this court in Arjun Pandit Rao, what is the position? Because P.V. Anwar was slightly modified in Arjun Pandit Rao. Now today Arjun Pandit Rao is holding the field. Now in this background, what they have said in this act, see, Section 63, earlier original provision 65B, we are all very familiar with that. Now they have repeated the same provision in Section 63 by slight modification. What do they say? Notwithstanding anything contained in this Adhiniyam, any information contained in an electronic record, please kindly see, digital record is not there. That's what I want to highlight. Digital record is not found. Any information contained in an electronic record which is printed on a paper, stored, recorded or occupied, copied, optical or magnetic media or semiconductor memory which is produced by a computer or any communication device or otherwise stored, recorded or copied in any electronic form, hereinafter referred to as a computer output, shall be deemed also to be a document. So, to explain this provision, I will give this example. So, some occurrence take place, it is captured in a CCTV camera, which cannot be manipulated. It is an electronic record. If the original itself is produced in court, then it is primary evidence. Suppose it cannot be removed from there, you can take a printout of that, a copy of that. That we call as computer output. Okay, as defined in this provision, it is computer output. When the computer output is produced in court, not the original, this is only secondary. The computer output is only secondary. Primary is still there in the house. This is only secondary. Now, this secondary evidence is also declared as a primary evidence, as a document. Also, it is declared as a document by fiction when you comply with the 65B certificate. If the certificate is produced, etc., etc. So it's a very long subject. I do not want to go into that. If Section 65B certificate is produced, this computer output, which is otherwise a secondary evidence, which is not a document, is now deemed to be a document. Okay, that is what it says. This provision has not been amended. See, computer out shall be deemed also be a document. Now, we have seen the definition of the term document, which includes electronic records and digital records, right? Now, this provision says, suppose a copy is taken from electronic record, another copy is taken from digital record. Both are computer outputs. How to prove these two? Section 65B of the old Act and the new Section 63 says that if it is a computer output taken from an electronic record, if it is accompanied by a certificate as required under the Act, it is also a document. Otherwise, it is not a document. It is also a document, therefore it can be admitted in evidence. My question is, suppose a copy is taken from a digital record, then can this be a document? Can this be brought under the provision Section 63? No. Then how to prove that? It is not primary evidence. See the dichotomy. If a copy is taken from an electronic record, it is also a document. provided the certificate is available. If a copy is taken from a digital record, section is not applicable. So there is no need to get section 65B certificate. It is not primary evidence at all. Then how to prove that? It is to be proved, it is still only a secondary evidence because it is only a copy. It can be proved as per the original section 65 of the Evidence Act, namely by laying a foundation that primary evidence is not available, therefore I am producing the secondary evidence. This will be contrary to Arjun Pandit Rao. Arjun Pandit Rao clearly says that the section 65 is not applicable at all to prove the document as a secondary evidence. Why? A special provision has been made. This has excluded the applicability of section 65. Therefore, you cannot prove that as a secondary evidence. So far as a copy taken from a digital record is concerned, what is wanting now is it can neither be proved as a primary evidence because section does not include that, nor could it be proved as secondary evidence because it is hit by Arjun Pandit Rao. This is again going to create confusion, and this is also to be settled by the Honorable Supreme Court. This is all about the electronic evidence, electronic record, digital record, all these things covered. Then what are the other changes made? Now, one or two I will say, then I will close my lecture. Other things are not very important because almost all the provisions, 99% of the old provisions have been simply incorporated except changing the order, section, serial number, etc. Nothing has been changed. What are the other changes made? Electronic evidence is the only thing which has undergone a major change by including digital records. So therefore, you please read it again and again, you will understand the difficulties that we are going to face. Arjun Pandit Rao would not help you at all. So far a digital record is concerned, Arjun Pandit Rao deals only with the electronic record, not digital records. For digital record, we do not have a judgment. So it is for the young lawyers like you to read, because you are all the people of these modern days, we are all old people. You can understand it very easily and you can place before the Honorable Supreme Court so that it can be helpful for others. Now what are the other provisions? Section 30 of the old code. Take section 30. Confession of a co-accused. Please kindly see, this is very, very important. A confession of a co-accused as per the original provision, when more persons than one are being tried jointly for the same offence, and a confession made by one of such persons affecting himself and some other of such person is proved, the court may take into consideration, etc. That is confession of a co-accused. Suppose A gives a confession, whereas he implicates B also. If there is a joint trial of A and B, the confession given by co-accused A can be used against B. I have already in my earlier lectures I have told you that this is not substantive evidence against B. We have got three judgments commencing from Bhubani Sagu of the Privy Council, then Kashmir Singh, then after that Kharchar and Gurmi, there is a constitutional bench. It is no evidence. Now, what they say, section 30 has been now incorporated as section 24. Now please look at section 24. So far as the substantive provision is concerned, there is no change at all, same thing. But they have added one explanation too, which say a trial of more persons than one held in the absence of accused who has absconded, or the word or, you have to give weightage for this, or who fails to comply with a proclamation issued under section 84 of the BNSS shall be deemed to be a joint trial for the purpose of this section. I tell you that this is going to create lot of other confusions. Reason number one is this. Now, earlier this Honorable Court has laid down this, by interpreting section 30 that unless both the accused are jointly being tried, the confession of one accused cannot be used. The latest judgment on this is Raja Alais Ayyappan. That is Raja Alais Ayyappan, Criminal Appeal number 1120 of 2010. Wherein this Honorable Court is very categorically followed the early judgment and has held that unless both the accused are before the court in the same trial, you cannot use the confession of one accused against the other. Now, what they say, if one accused is absconding or there is a proclamation against him but he doesn't appear, it shall be deemed that he is facing joint trial and therefore his confession can be used against the accused who is facing the trial, actual trial. By fiction they do this. So I will illustrate this. A and B are the accused. A has given one confession, judicial confession, B has given another confession. Now B is absconding. What is the value of the confession of B as against the A? Whether it is admissible? As per section 30 of the Evidence Act, it is not admissible because there is no joint trial. Now they say B is absconding, but it is deemed that he is facing trial along with A, and therefore the confession given by B can be used against him, against A. So by fiction they say that there is a joint trial, though virtually there is no joint trial. Now this is again contrary to the old section 317 of BNSS and the corresponding new provision. There is no change in that. What section 317 of the old code says? Suppose one accused is absconding, the court is empowered to split up his case and it will be kept separately. Trial will go on against the accused who is present. See, 317. The judge or magistrate may, if the accused is represented by a pleader, dispense with his attendance and proceed with such inquiry or trial, and may at any subsequent stage insist for his presence. That is 317 petition. If the accused is not present, advocate can be present. That is, if the accused in any such case is not represented by a pleader, no lawyer is appearing, or if the judge or magistrate considers his personal attendance necessary, he may, if he thinks fit, for the reasons recorded by him, either adjourn such inquiry or trial, or order that case of such accused be taken up or tried separately, splitting up power. That is under section 317, subsection 2 of the old code. The corresponding provision is 355 of the new code. Same provision. So here, in a given case, as per this provision, because the accused is absconding, case is split up. So far B is concerned, case split up and is kept separately. Now A faces the trial. You say that by fiction, it is deemed that that confession is admissible because there is a joint trial according to the fiction. It can be used against A. Now let us assume that based on that A is convicted. Subsequently B is secured. B faces the trial. Whether confession made by A can be used against B? Cannot. What is the reason? There is no joint trial. The provision say when one accused is absconding, it is deemed that he is facing trial jointly. Here A is not absconding, he faces the trial, he is very much available. How can his confession be used against this man, against B? I do not understand this provision again. There are so many other difficulties, not only this, and we do not find time to deal with all those things. And there are so many other difficulties also in this. Under the BNSS, that is the new CRPC, we have already seen that though the accused is not present, you can go ahead with the trial, you can convict him, we got to deal with them. Now that is section 356 of the BNSS. If the accused is absconding and he is proclaimed as an offender, the court need not split up the case. The court can try the case along with the other accused. So there is joint trial. The man will be convicted without facing a trial at all. Now, the problem is this section 356 speaks of trial in absentia where there is a proclamation order. But this provision speaks of absconding or proclamation. In either case, the confession of co-accused is admitted in evidence. This is again totally wrong. It cannot be. So if a person is absconding, if you say that there is deemed joint trial, then the difficulty which I already narrated will come. I do not want to repeat the same. If you say, no, there is proclamation, therefore there is a joint trial, then that is as per section 356 of the BNSS, then there will be nothing later point of time to hold another trial. There will be only one trial. So these are all the difficulties which we are facing, and so many other difficulties are also there. So for want of time, I am not able to concentrate on, focus on all those provisions. I think that this is enough. Sir has given me a caution also. With this, I think that other things, if time permits in future, after some judgments of the Supreme Court, we can have discussion. With this, I want to conclude our debate or discussion on this new evidence act, namely this BSCA, Bharatiya
Sakshya Adhiniyam.
Bharatiya Sakshya Adhiniyam. With this, I conclude. Thank you so much for your patient attendance. Thank you.
Can I ask you one question?
Please. Tomorrow questions. Thank you very much, sir. You have 40 years experience in criminal science as a trial lawyer, as a high court lawyer, and judge, and particularly Supreme Court. We are highly grateful, sir. 1, 2, 3, 4 chapter extremely nicely you covered. You enlightened us. We are highly grateful to you, sir. Let us give a standing ovation to sir. Small announcement. Tomorrow is a conclusion. Small celebrations. Please kindly join same time.
Tomorrow I will touch upon, because we have not dealt with that IPC, the new Nyaya Sanhita IPC. Tomorrow I will, so there are lot of, not too many matters to be discussed. I will do it in 20 minutes, then we can have
Yeah. Celebrations, sir.
Thank you, sir. Thank you so much.
Thank you. Kindly join for cup of